Hello friends, in the series on income tax cases, today we will discuss a case in which the addition of the assessee was made under section 68 on the basis of the statement of the directors of the assessee that they have received the accommodation entries from J group of companies. The issue before Honorable Delhi High Court was that whether there can be a presumption of the presence of incriminating material, whether the addition can be made just on the basis of the statements of the directors of the assessee company, especially in case where the statement of those other persons where the search has been made has not been provided to the assessee, no cross-examination has been provided to the assessee. So whether the addition just on the basis of the directors of the assessee company that they have taken accommodation entries can be made in the absence of incriminating material. This issue has been taken up by Honorable Delhi High Court in the case of Principal Commissioner of Income Tax versus Pavitra Realcon Private Limited, and this case is reported in 481 ITR at page number 663, and the date of the judgment is 29th May 2024. The present case relates to the assessment year 11-12. In the present case, there was a search in J group of companies. The statement of the owner of the J group of company was recorded, and consequently the statement of the directors of the assessee company were also recorded. In those statements, the directors of the company were not able to explain the advance against property of an amount of rupees 325 crore, and they admitted in their statements that this amount has been received in exchange of cash to the J group of companies. When the assessment proceedings were going on, the assessing officer made the addition under section 68. The submission of the assessee was that the statements are not supported by the incriminating material. There is no material found, and the assessee was also contending that the statements were given under some pressure at the time of the recording of the statement. So this is a routine feature. But the assessing officer made the addition in the absence of any incriminating material, which was upheld by the CIT appeal. When the matter was before the tribunal, the assessee was also raising an additional ground that the assessment has been made under section 143 subsection 3 while it should have been made under section 153C. This was the first time the assessee was raising this ground. When the tribunal heard the matter, the tribunal said that in the present case, the assessee submission that the satisfaction note which has been recorded is mechanical in nature. The statement of the owner of the J group of companies has not been provided to the assessee, and the opportunity of cross-examination has not been provided to the assessee in spite of specially made demand by the assessee in respect of cross-examination. The tribunal said that in the present case, the additions have been made just on the basis of the statement of the directors that they have received some accommodation entries, but the revenue is not able to produce even a single document which shows this thing, that there is some incriminating material which shows that the assessee has taken accommodation entries. The tribunal was of the view that in the absence of any incriminating material, in the absence of any evidences against the assessee, just the addition on the basis of the statements cannot be made. The tribunal said that there is no doubt that the statement recorders do have evidentiary value, but in the absence of incriminating material, they loses their significance because there should be some liveling between the incriminating material and the statements recorded. When the revenue filed the appeal before the Honorable Delhi High Court, the Delhi High Court was also of the view that the additions made on the basis of just the statements of the directors of the assessee company is not valid. Friends, this case is very important because the clinching fact in this case is that the directors of the assessee company have admitted that they have taken accommodation entries. They have surrendered that income. In spite of that, in the absence of incriminating material, the additions was deleted. But in routine, we see that a lot of additions are being done on the basis of the additions of the third persons without providing the copy of the statement, and even if the copy is provided, they are not legible. They are not legible to read. So this case is very important where the additions are just made on the basis of the additions without providing their copy, or the opportunity of cross-examination. At the end of this video, once again, I am repeating the name of the case. The name of the case is PCIT versus Pavitra Realcon Private Limited, and this case is reported in 481 ITR at page number 663. The date of the judgment is 29th May 2024. Thank you, friends.